And after extensive consideration, the judge says, drum roll, the court answers the question in the affirmative. Can the president do that? Yes. May he issue a proclamation? Yes, obviously. He's the president. If the American people are mad about this, they can speak to their representatives and they can impeach all these people and remove them. But they know that the people are happy with this. A victory for President Trump. We see this case is coming out of the Western District of Pennsylvania, and a victory for the president is a victory for us since we elected him. We didn't elect these judges. But what has happened is in these cases, you see this one is involving ASR, and ASR is not an organization, it's an acronym for a person's name. ASR is an individual who doesn't want to get deported and is suing the government essentially to say, you can't have lawful detention over me, you can't deport me by invoking the Alien Enemies Act. And what we've seen here is judges all across the country have found little justifications to find in their favor, certifying them as class action gangbangers, saying that they're not getting proper due process, basically holding Trump in contempt, ordering discovery, and just kind of mucking the whole thing up. Even the Supreme Court has issued a stay and ordered Trump to stop the removals of a lot of these people. But now this decision comes out of Pennsylvania, and this judge gets it right finally. And we're going to see, I think, a lot more of this as the forum shopping starts to dissipate. Remember, they went and picked the most favorable judges for them to give them the rulings that they wanted. And now we're seeing some actual legal logic start to bubble up. So here is what is happening here. The person who is in this case is called ASR. This is a Venezuelan man who's an illegal, currently in immigration custody, and they say he's subject to the AEA, Alien Enemies Act. He's got to go. Now, he has requested that this court in Pennsylvania say these three things. One, that Trump's proclamation is not in alignment with the Alien Enemies Act. Okay, so Trump came out, issued an order, and that order is out of the law. The law, Alien Enemies Act, was passed by Congress. It says you can use it for these things. Trump is not using it for those things. Therefore, it is unlawful. They also want to say that the due process is currently insufficient. And so that's generally what the Supreme Court has told us is notice and opportunity to be heard. Okay, do you have notice of what's happening to you so you can challenge it? And is there an actual opportunity to do something about it? So they want a lot more due process, and the judge is going to find in their favor a little bit more on that one. But the big one is this first attempt here, right? This would invalidate Trump's entire proclamation is the theory. And then they want other relief. Now, the judge writes this case, the Alien Enemies Act, it poses significant issues to our country and to us that are deeply interwoven with the constitutional principles upon our founding. And so we have to begin by stressing stuff that we are not resolving right now, right? It's a very prickly position. Now, this court is not resolving the question of whether the president may direct the removal of certain people, and the court is not resolving the question of whether the president, okay, so kind of making a Venn diagram, kicking the president outside of that, because we have a real separation of powers problem if the judge is ordering the president to do anything, as you can imagine. And the court is not resolving a lot of those things. And third, the court is not resolving the question of whether individuals who are subject to removal are entitled to notice, okay? Like that's already been decided. The Supreme Court has said you already are entitled to notice, right? SCOTUS said that. We were always fine with that. You're entitled to notice and an opportunity to be heard, and you can go file in habeas in Texas. They didn't want to do that though. They wanted class action gangbangers in Judge Zenus's courtroom. Instead, the question the court is going to answer here is this. So long as the government gives sufficient notice and due process, may the president issue a proclamation under the AEA doing what he did, right? Venezuelans, 14 or older, in the United States, neither actually naturalized or lawful permanent residents, so they've got no lawful status to be here, who are members of Tren de Aragua, which is a foreign terrorist organization. So can the president do that? That's all we're asking. And after extensive consideration, the judge says, drum roll, the court answers the question in the affirmative. Can the president do that? Yes. May he issue a proclamation? Yes, obviously. He's the president. So therefore, the judge explains in detail. Because this court finds that the president can do this, the court denies their request for an injunction. Now, the court does say that you do need more notice, essentially. The notice, right? You got to give them a little bit more sufficient notice. And so accordingly, we'll make you do that. Now, here's the background, right? We know what the AEA says. It says the president may make a public proclamation, predatory incursion, enemy invasion. And that is exactly what Trump did. On March 14th, boom, comes into the White House, says we're taking care of business, TCB. Says Tren de Aragua is closely aligned with and has infiltrated the Maduro regime, and they're terrorizing our country, right? There's the whole proclamation there for the record. Writing, as a result of the foregoing, Trump found that TDA is perpetrating, attempting, and threatening an invasion or predatory incursion, right? Those are those legal terms of art. They're going to say many different parts of the statute they're going to challenge. Oh, they're not enemies. They're not like labeled enemy combatants with an enemy uniform on, carrying an enemy flag. No, it's a little different than that, but they would want you to have a much more narrow definition of who qualifies. Explaining, Trump concluded these things and wrote it into the proclamation. Now, the court is going to give us an overview of the law. It says, well, the Secretary of State can come out and do these things. And as the Supreme Court has explained, national security means a bunch of stuff, things like national defense, foreign relations, economic interests, and more. And an entity that is designated a terrorist organization, they can challenge that, okay? Like if Tren de Aragua says, hey, wait a minute, we're not gangbangers. We just are innocent pupusa bakers. How dare you? Well, then they can challenge that, okay? The law says they can go to DC Circuit and they can challenge that. If they say that we're not actual terrorists, there's a mechanism. I did not know this. This is hilarious. The gangbangers just go sue. We're officially, who are your lawyer with? The ACLU would probably represent them since they're basically an extension of Tren de Aragua anyways at this moment. So just go sue. Just say, no, we're not. We're not a terrorist organization. They didn't do that. And there's a bunch of procedures. And Congress can also have a remedy on this too, right? So there's a bunch of stuff they can do. The DC Circuit can hold a designation unlawful if it's arbitrary, capricious, contrary to the constitutional power, in excess of statutory jurisdiction, lacking substantial support, not in accordance with procedures, and more. And Congress can also override that. If you say, hey, Tren's a terrorist group, foreign terrorist organization, Congress can say, no, they're not. So on February 20th, Rubio also found that Tren and 7 other organizations were FTOs. Bunch of them. Tren de Aragua, Mara Salvatrucha, Cartel de Sinaloa, Jalisco, Unidos, all of them. They're all on the list. And the record, writes the judge, supports the evidence. We also have 2 declarations that Trump submitted. The first is a declaration by this person called Selwyn Smith. This person's Deputy Assistant Director, aka DAD, for Homeland Security. His acronym is Dad Smith. And Selwyn, is that a dude? All right. So in Dad Smith's declaration, he provides significant background based on his personal knowledge and experience. He says, oh yeah, no, TDA, Tren de Aragua, their growth, their spread throughout the United States is rampant. Members are involved in illicit activity. They invoke fear and supremacy in neighborhoods. They take over Denver apartment buildings. They traffic women from Venezuela. They commit bank fraud, narcotics frauds. They traffic human beings, homicide, many other things. And they are now present in the United States, committing criminal activity in 40 states across our country and in Canada. And Dad explained that the NYPD recorded a surge in robberies that they believe are happening by TDA recruits, right? You got to go commit these robberies if you want to be in our gang. Now, accused leaders of this group have also admitted they've got a complex network in Florida and Texas, and they ship their profits back to South America. And crews of the Tren de Aragua network are also involved in extortion and ransom schemes and more. This guy says they pose an extraordinary threat to the American public, obviously. Now, the second is a declaration by Michael Kozak, and he's a senior bureau official from the Western Hemisphere. He said in his declaration that he's also got extensive work in Venezuela and elsewhere. And according to him, he says U.S. government officials from the White House and the State Department have negotiated at the highest levels with the government of El Salvador, with Maduro and his representatives in recent weeks, for those countries to consent to the removal of, to Venezuela and El Salvador, some of the Tren de Aragua members. Kozak says, actually, yeah, we reached agreements to this effect so that foreign interlocutors would accept the removal of some of the Tren gangbangers. These arrangements were the results of intensive negotiations between the United States and El Salvador, and there were also representatives there of the Maduro regime, right? So we've got MS-13 in Tren de Aragua, and we got to keep them separate. MS-13 is the Kilmar case in El Salvador, Tren in Venezuela. Now, against this backdrop, the judge says, so that sounds like pretty good evidence, right? We've got 2 declarations from government officials who are all saying that this has to be considered. It's a real threat to the country. Here's why. Now, against this backdrop, the court turns its attention to the factual and procedural history of this case. Now, there's a big question over jurisdiction. This has actually been a big issue because of habeas, right? And the Supreme Court saying, Judge Boasberg, you don't have jurisdiction. You have to send this back to where they're being housed. That happened to be Texas. What happens in Texas is not favorable to them, which is why they want to keep it in DC, where they have all their favorite judges. So the judge is going to walk us through this. Says, all right, listen, here's what happened. On April 15th, not long ago, this person filed a petition. Now, on that same day, he filed a TRO. So files this by himself, habeas petition, right? Which we've never been opposed to. Neither has the DOJ. It's always been appropriate. Yeah, if you want to individually file because you say this is wrong, go for it. But you don't get to be certified as a class and then file a constitutional claim that invalidates the entire proclamation everywhere across the country. Are you crazy? So he did that, right? He files his habeas, and then I don't know if he's got the ACLU lawyers or whomever on his case, but then they file the TRO, which the judges grant as the injunction, and then the motion for class certification. So then we get class counsel, which is going to be the ACLU gangbangers, right? Because they got appointed for the entire class by other judges. Now, this illegal represents, he says, at the time he filed his petition, he says, I'm a Venezuelan common man, probably a barber or a PhD philosopher or makeup artist or something. He says, I'm at imminent risk of removal. Now, along with his petition, he also submitted a declaration from his gangbang lawyer. Now, in that declaration, the lawyer made the following statements. They said, hey, I'm a gangbanger lawyer, and on April 14th, he was detained here. He's a citizen of Venezuela, born in 95. He was put on the intensive supervision appearance program. During that time, ICE arrested him and told him his neighbor reported him. Neighbor called, said, you're a member of Tren de Aragua. Neighbor called him in. ICE asked him about his tattoos. Oh, ICE filed an I-213 accusing him of being affiliated with TDA. Now, while he was detained at MVPC, this is the lawyer speaking, he was in pending immigration removal proceedings with an immigration hearing scheduled in Elizabeth Immigration Court. So it sounds like parallel things happening, right? He's got two different bases for removal. One, Alien Enemy Act being Tren de Aragua. The other, he's just an illegal. ASR denies that his tattoos are connected to Tren. He vehemently denies any connection to that organization. No, clearly, and we all know they're just tattoos to remember his auntie who died when he was a boy. Yeah. Finally, according to his counsel, his lawyer, it appeared that he was at grave risk of removal because he's TDA. So then on April 15th, this court entered a TRO, temporarily stopping his removal. Said, all right, we don't know. Let me hold up. Judge paused everything. Said, okay, we'll come back for a hearing on April 18th. Then on that date, before that, the court was notified that they transferred this dude to Texas, right? So they then moved him. So she's going to say, okay, you moved him, but I had the case before you moved him. The government also submitted a declaration. Yep, we moved him from Pennsylvania to Texas. The court then held a status conference. The government would have said, well, you don't have jurisdiction anymore because we moved him. She's like, no. After receiving briefs, everyone agreed that he was present when he filed. He's no longer there today. And because he was there when he filed, the court has jurisdiction. So the court held that the TRO would remain in effect, right? So everything would be paused. And it said, don't remove him from the country. Keep him down there, but he's got to get notice in English and Spanish, and he's got to have interpreters if they need them, and, red carpet, ACLU lawyers and all the things, because they get more rights than you, because they're better than you, according to our own government. Now, finally, the court informed ASR he was permitted to file a motion, and if he did, we'd have a hearing. So then we had another hearing, and it was about certifying a class, and the court notes there's going to be a separate opinion on that and more. Now, then they filed their response, and the reply came in, and then we conducted the hearing. Now, during that hearing, two things occurred that are especially relevant here. With respect to jurisdiction and standing, counsel for Trump indicated that he could not guarantee this court with absolute certainty that the government will not deem ASR to be subject to removal in the future. Say, we can't say that. There might be some other proclamation. He might come under it in the future. And second, with respect to notice, they said, we're currently giving 12 hours of notice, right? They're like, okay, that's not long enough. They say, well, 12 hours, they get notice and they can file or not. Otherwise, they're getting on a plane. It's like, midnight, you're leaving at lunch. So here you go. Here's your notice. Get a lawyer or you're out. If an individual indicates that he wants to file, then he gets another 24 hours. And if he does file, then they won't remove him. So this court begins by asking these basic questions. Do we have jurisdiction over this case? She's going to find, yes, we do, and make a ruling. As the Supreme Court says, federal habeas gives district courts jurisdiction where they're in custody. Now, even though you moved this guy, he was here and then moved. He was scheduled for an immigration hearing in New Jersey on April 15th for another reason, right? This kind of complicates things because he was also being processed under the INA. So think about it like two separate tracks or like two separate almost crimes or prosecutions, right? Both leading to removal. But the INA is just regular immigration stuff because he's not lawfully here. And then the Alien Enemies Act is Trump's new proclamation. So if I take those both together, the court is left with the following question. She's like, gosh, if he has always been in custody under the INA rather than the AEA, right? Because then Trump is saying, actually, when we had him in custody under the INA, which is over here. So that's why we moved him. So you actually never had jurisdiction. They filed in the wrong spot. They said, well, if that's true, if he was in New Jersey, then why'd you move him to Texas? The court can't square this circle. And it seems like his abrupt movement is evidence that he was then in custody. So she's just going to say, I have power over this guy. The evidence to which they cite does not say that they determined that he was not removable under the proclamation. And in short, while the court has before it indications that he was in custody under the INA, which they're not suing under, the court finds that to believe those representations would be to exalt form over fairly significant evidentiary substance. And so the court is going to find that on April 15th, when he actually filed his habeas petition, he was in custody pursuant to the proclamation and the AEA, right? So I think you could probably split hairs on that. And she's just going to find in favor. She's ultimately going to give us the outcome that we want. So it's not really consequential. Accordingly, this court had jurisdiction over him and finds that even if they did move him from removal proceedings or to removal proceedings under the ANA, right? So, okay, well, we got this guy under the AEA, but now we're not going to use that. that. We're just going to use the INA and drop that other case. Like we got this guy for, possession of narcotics, but we also got him for possession of dangerous drugs, right? And some other classification of drugs. And so then you just pick one, drop the other, pursue that claim, and that's your discretion to do that. She says, well, you might, but I'm just going to hold that you had him basically in custody for both reasons, and the fact that he filed this while he was in custody gives me jurisdiction over it, and I'm going to liberally construe the custody requirement for habeas. And so now it's about standing. Do they have the ability to sue? The court finds that yes, he does have standing. He was personally facing removal, and Trump is kind of saying, well, we're not actually subjecting him to the AEA though. Now we're just going to use the INA, not the AEA. She says, well, if we assume that he's no longer subject to the AEA, then we have to ask whether mootness applies and more, whether this could come back, right? She's like, well, if I dismiss this is capable of repetition yet evading review, which is this concept that you don't want this to come back, right? Because then Trump could do this every time, kind of like file something and then change his strategy and then dismiss it. And then the court will like, well, I still want to rule on that case. So since you could do this and evade review, I'm going to hold on to it and make a decision about it. Now on April 7th, she writes, the Supreme Court heard an appeal regarding Trump's proclamation. And they said that individuals subject to removal had to have judicial review or could have judicial review as to the interpretation and the constitutionality of the act, right? So the Supreme Court came back down and said, judicial review of this act is limited. Judges can't just come in here and say, well, actually, Trump shouldn't have done that, or this was a bad decision because I'm the judge and I think it's smarter if we do it this way. Well, you're not the president. Don't get to make those decisions. So the Supreme Court noted, it is limited. You can't substitute your opinion, but if you are subject to removal, you do get some limited judicial review. Of course, maybe the interpretation and the constitutionality of the act. Like what if Trump came out and said, all lawyers are enemies of the state, and you're all going to be deported of this country because I hate lawyers or something, right? The courts would probably come back out and say, well, you can't just codify that group of people as alien enemies. There's no evidence of that. And so they would find that proclamation to be invalid, generally speaking, right? Now, because you might say that's arbitrary and capricious. Now, if Trump in this case, right, has a bunch of evidence and declarations from other people that say, yeah, Tren de Aragua was pretty bad, MS-13 is pretty bad, then you can't question that judgment. So it's kind of a different, I would say, scope, magnitude, and it's that line of arbitrary and capriciousness, and where do you reach that? But here, does it apply? Are you 14 years of age and older? And here's what this judge finds on that basis. Says clearly, based on this statement, the court can interpret some of this, the meaning and the words of the terms within the AEA. For example, what does invasion actually mean? What does predatory incursion actually mean? And this court may also consider questions like, is notice appropriate and more. They said reasonable time in the Supreme Court that actually allows them to seek habeas in the proper court. And the court also may theoretically assess the constitutionality of the AEA. And although the issue is well settled in favor of the act, the court may assess, is the individual subject to the AEA? A question that they're not presently pressing upon this court because that's in habeas, right? That should be filed elsewhere. Now here, they tell us, however, the judge says, this illegal wants a more intensive inquiry when he says that Trump and his proclamation cannot survive and must be declared illegal because they are simply incorrect as a factual matter, right? There is no predatory incursion argument. There is no invasion argument. Tren de Aragua is not an alien enemy. And here's what this judge says. You've invited me to make that assessment, but I'm going to decline to do that. Not going to happen. The court first notes that in the JGG case that went up to the Supreme Court, it doesn't give me permission for this court or any court to weigh the truthfulness of the factual representations within the presidential proclamation. Trump said this is happening. The judge can't say, actually, no, it's not, because I read CNN and Jake Tapper told me so. You don't get the right to say that, Judge. He's the president. You're not in a position to do that. Noting that judicial review is limited and the proper subjects are interpretation, constitutionality, is an individual, in fact, an alien enemy, and more. And in another Supreme Court, they also expressed hesitancy to wade into weighing whether a state of war even existed. That's not for the judges to decide. A reality that triggered the declared war component of the AEA and permitted the president to use the act. They can't substitute their judgment for that. Now, in this same vein, the district court for the Southern District of Texas that we talked about yesterday recently concluded that after a court construes the meaning of these terms like invasion or predatory incursion, it's up to the executive branch to determine whether that has occurred. Now, as to this decision, the court may not delve into whether the executive branch possesses sufficient support for its conclusion. Well, Trump should have done a more strenuous analysis on Tren de Aragua. Or whether the court agrees. You don't get to make those interpretations. That analysis would require the executive branch to disclose to to the court the undergirds of a finding of what a predatory incursion is. And that is contrary to the law. They're not required to answer to you before they make those decisions. Before leaving this subject, this judge says, the court also notes, the Southern District of Texas also concluded that the presidential declaration invoking the AEA must have sufficient factual statements so that the court can make a decision. Now, you don't have to disclose everything, but you got to give the court enough to say, okay, like that's good enough. That meets the standard. Now, this articulation of the law appears reasonable, appears correct to me, says the judge. And as the court finds below, Trump's proclamation meets this standard. It's lawful. Therefore, the court doesn't need to spend extensive time working out the nuances of any of this. They did it in Texas. And the court assumes, without deciding, that the Southern District of Texas is correct on this issue and proceeds accordingly. And so now let's get into the law. Of course, we know what the standards are for a preliminary injunction. One of those standards is the party who wants the court to do something. Are they going to win on the merits? Are they going to win the case? When interpreting a statute, the court's job is to look at the ordinary meaning at the time Congress enacted the statute. And we can look to dictionaries and more. Now, in the context of a constitutional rights, we have to look to ways of interpreting what the law says. Now, what happens here is that Trump says, here's the meaning. A predatory incursion, like what Tren de Aragua and the AEA is doing, under the AEA means entry into the United States, that's all, for the purpose that are contrary to the interest or the laws of the United States. That's it. That's Trump's elements. Just going to check those two boxes, and that's going to be it. Now, the court deems that definition deficient. Okay, she's like, it's not big enough. Somebody came in and it's contrary to our interest, like that's all? The judge says, well, it's not really good enough there, Trump, but here's what I'll find. The court's basis for this finding is rooted in the dictionary definition of the words. What does predatory mean? What does incursion mean? If you look back to a 1773 dictionary, predatory means plundering or practicing rapine, hungry preying, rapacious, ravenous. The same dictionary defines incursion as attack, mischievous, occurrence, invasion without conquest, inroad, ravage. In 1828, predatory meant plundering, pillaging. It also said predatory war was like a predatory party, predatory spirits or appetites. They define incursion and other definitions. Now, the court pauses here and says, first of all, this is interesting. So Trump says this, the definitions say this. There's at least two characteristics that I'm seeing in these words that we're not seeing in Trump's definition. First, they speak of a cohesive unit, so it's like a group of something entering for a united purpose. Now, Trump's definition is deficient, as Trump's definition could apply to a single person, like there's no collective element to that. And second, these definitions indicate that incursion was commonly referred to military activity back in 1798. Now, their definition is also sufficient because it doesn't account for common and significant destructive purpose for which a cohesive unit must enter. Okay, that's what a predatory incursion is. So the judge says, oh, that's complicated. Now, our initial observations about the meaning of predatory and incursion are confirmed by the use of those words back in 1798, telling us, in 1805, the Supreme Court referred to hostile incursions at the hands of Indian tribes within the context of war. Now, this action was taken by a cohesive unit. They had entering a territory. So like, just think of these like checkbox, got that one. Entered a territory, common and significant destructive purpose. Okay, so check the boxes. And the Supreme Court also quoted a charter in 1832 to William Penn of Pennsylvania containing the following language. He said this, because in so remote a country near so many barbarous nations, the incursions, as well as the savages themselves, as other enemies, pirates and robbers, may probably be feared. And finally, based on its extensive consideration of other cases in 1798, Texas also found an incursion referenced the military force or an armed, organized force that came in to plunder your booty with the subsequent retreat. So therefore, the court says, well, Trump's definition doesn't really get to the AEA. Okay, migration alone, so somebody just coming across, it's like contrary to our interest because we don't want illegals here, that alone is not enough as a predatory incursion. But the proposed definition would lead to certain migration alones qualifying, and that's not what it's for. But so if that definition doesn't work, what about the other definition? So the other side, ASR, the illegal, and his gangbang lawyers, right? Well, they say it has to be very specific. Like it has to be a military action by a foreign government. So their checkboxes, it has to be military, like probably in tanks with bazookas, by a foreign government officially in uniform that constitutes or precedes an act of war. It's like, okay, so basically we would never have one of those unless it was an act of war. So why are we just going to war then? Like if they're going to do that, are we just going to declare war on them? What's the difference? They say, mass illegal immigration, criminal activities, gangbangers, that's not what the law's for. And the court agrees with some of this. They say that the predatory incursion does require a cohesive unit coming in. Migration alone is not there. But the recount from this gangbanger illegal of the proclamation suffers from one defect. It omits the fact that here the court is not dealing with mass illegal immigration or criminal activities. they've been designated terrorists. Hello. And they did it through the legal process. Now, the fact has been weighing heavily on this court. They're terrorists. They're not just regular criminals. To reiterate, the Secretary of State may only designate terrorists when they engage in terrorist activity. And when that happens in the United States under the law. And an FTO, if you are a terrorist organization, you can sue. You can seek extensive judicial review. And Congress can reverse that. Maybe go to Senator Chris Van Hollen, all right? And he'll tell you, these are good people who are in our country for a better life after they beat their spouses and traffic illegals. In light of the foregoing, the judge says, coupled with the fact that the Supreme Court has considered a statute's meaning as fixed, but its application subject to change, the court must ask another question. Is a duly designated terrorist organization that meets the law, and if that person enters the United States to destabilize, is that not the very definition of this? Is such a terrorist organization not the modern equivalent of enemies, pirates, and robbers committing incursions, just like back in 1798? And those of you who've been with us for a couple weeks have said, well, we've been waiting for this, right? All of the terror analogs are going to come back out. Because if you can say, terrorist is an amorphous term that we can use to do a bunch of stuff, like including spying on our own people and violating our Fourth Amendment rights and issuing FISA courts and all these things, then how can you carve out kind of an exception to terrorism for these terrorists? It's like totally illogical. This judge is asking that same question. It's basically the same, like it's morphed into terrorism. And there's case law out the wazoo supporting this back during the post 9/11 stuff. So first, the AEA, she says, does not require that an invasion or incursion be perpetrated by the military of a foreign government. That's not in the law. The words are not present in the text, and the word military is not in there at all. So if predatory incursion requires a military, that must come from the word predatory incursion as of 1798 and not from the statute, and it's not in there. Now, in second, the word terrorist and terrorism were not in any significant use in 1798. Neither of the dictionaries even had that word. Further, based on the court's review, the first word terrorist was back in 1941, and the first use of terrorism that the court could locate was back in 1880. Since those words were not even in significant use under the AEA, we can't really make an equation between the two, right? Predatory incursion is analog to terrorist activities because they already knew how to declare war, right? They already had that in the Constitution. That was a known tactic. Now, third, modern definitions of predatory incursion also match the definitions back then. The current definition is plunder, pillage, inclined to injure, personal gain or growth, Merriam-Webster's, a hostile entrance into a territory like a raid. An incursion is into enemy airspace and more. So at this juncture, the court invites the reader, that's us, to turn to the preceding subsection and reread that. No, but we got the point. And fourth, she says they're basically the same, right? It's predatory incursion is fairly being applied to terrorist organizations. It was this kind of catch-all for these other groups of bandits and robbers and pirates plundering booty. Now, fourth, as the terms terrorist and terrorism has become more common, courts around the country have used incursion in ways that support this. For example, in 1873, the courts recounted how carriers were sued for the loss of gold. In 1961, there was another case. In 1992, in 2013, bunch of these examples. So to recap, the word military is not found in the AEA. So it's not a military entity. Terrorist and terrorism weren't even used back then, and predatory and incursion have similar definitions as they do today. Terror organizations are repeatedly referenced in case law as predatory groups, and there are cohesive groups that have a common and significant destructive purpose. So in sum, based on the Supreme Court statement that while the meaning of the statute is fixed, new applications may arise, and this court has continued to ask itself, if terrorist organizations existed and were entering the country back in 1798, would the public and the Congress back then have viewed these as incursions? Yes, of course they would. They would call those predatory incursions. If we had Tren de Aragua attacking George Washington's family. Now, the Supreme Court respects the conclusion of the political branches in the realms of national security, since, that's their job, and therefore the court rejects the gangbangers' use and definition of predatory incursion. And so, in light of all of this, Trump's proclamation got it right. And we reach the following definition of predatory incursion. Here's the judge's definition. We'll see if this catches. It is a hostile entry into the United States, Tren, MS-13, by a cohesive group of individuals in a gang, such as a military detachment or an FTO, who are united by a common goal of causing significant disruption to the public safety, whether people, property, or pecuniary interests of those in the United States. So she just kind of cobbled that together and said, I think that's an appropriate definition based on on my interpretation, and the court finds that is meaning and faithful to the meaning of what they wanted back in 1798. And there's a new application which is applying that to terrorism. And when this court does that and applies Trump's proclamation to its finding that Tren is committing a predatory incursion, they follow the law. The proclamation and the declarations provide a factual basis. You might disagree with the factual basis, but they provided it. Secretary of State designated it. The law heavily supports conclusions that within the proclamation that TDA is a cohesive group, and there's other declarations that have been submitted. And further, this court also finds that the documents that are referenced by the proclamation support the finding that there is an incursion. There's a common disruption, common safety, just like in other cases. There are military detachments and pirates around the time back when Congress enacted this in 1798. And now this entity is designated an FTO. They're hell-bent on destabilizing the U.S. They're flooding the United States with illegal narcotics. They're using the drugs as a weapon against our people. And all of that meets the requirements. And so for the foregoing reasons, this judge says the proclamation meets the definition. And the illegal has not shown a likelihood that they're going to win on this matter. And it also satisfies this checkbox of being against the United States. The AEA also says it has to be against the territory of the United States. And the illegal says, well, that means it has to be a military. The court has already explained why that's not right. Against the United States is much broader than just a military attack. And turning finally to the phrase a foreign nation or government, saying we're going to afford substantial deference to the conclusions of the president on this. This is a sensitive and weighty issue of national security. The deference is mandated by the Supreme Court. It's due to the fact that neither members of the Supreme Court nor judges get the daily briefings. They don't get any new information. And so they're not in a good position to make a good judgment. The court also notes it's not our power. The president alone has the power to make these determinations. And so therefore, the court will accept as true Trump's conclusion via the proclamation that Tren is acting at the direction of the Maduro regime. And now, based on this conclusion, the court is in full accord with Southern District of Texas. They say the same thing. They say, although the proclamation in Texas focuses on TDA's activities, it places control of those activities in Maduro, and it declares Venezuela, through Maduro, directs Tren in America and concludes they're responsible for that. Now, you might disagree with that determination, but you're a judge and you don't have the information to make that decision. So you don't get to substitute your analysis. If the people think that's wrong or Congress thinks that's wrong, they can do something to reverse that. But under the law, it meets the requirement. So in light of the foregoing, the court finds that Trump's proclamation complies with the law, and therefore we turn our attention to the notice that is being provided, right? So this is where the judge is going to throw them a bone. Says, now, while the respondents say that the ASR is not being detained to the AEA because they're being detained under the INA, we do want due process in terms of notice to be provided. The Supreme Court has held that detainees are entitled to notice and an opportunity to be heard that's appropriate to the nature of their case. It's habeas, and they have to actually be able to seek it. Now, far in excess of the notice requirements, this court said that 14 days meets due process. But when the court reached that decision, it also certified a class, and the court was of the mind 14 days was sufficient. But now, because the court finds the legal requirements of a class are no longer satisfied, the court must also consider how much notice is appropriate absent class certification, right? So this is like a double dip. They lose on the AEA and they lose class certifications. But when the court conducts that inquiry, the court says 21 days notice is an adequate time. First, the court is intimately familiar with ICE proceedings and the region, and so we know that they're moved a lot and they need an opportunity, so 3 weeks. Now further, pursuant to the Supreme Court's admonishment that they're notified of removal, the court will continue to require they get it in English and Spanish or whatever language, and they get interpreters if needed. Finally, with respect to this particular case, because this guy has a lawyer, he gets notice on everything as well. And if he wants to challenge it, he can file individually. But their other arguments are unavailing and they lose on those. They say it's fundamental that Trump found all members are, by virtue of their membership, hostile to the United States, and there's a finding of factual support here for that. And he does not need to give them an opportunity to deport prior to removal, right? So he doesn't have to give them an opportunity to self-deport. They want to self-deport because they don't want to go to CCOT. That's their prerogative. They should leave now. Second, they also say that Congress wanted the INA to supersede all of their previous laws, and she says, no, I can't find that either, saying, in light of all the foregoing, the court denies the motion for an injunction on all of the major issues. Now, as the court explained above, the Supreme Court has explained that there are other remedies here, and there's not going to be any additional harm. harm on this. And so in conclusion, the judge, Stephanie L. Haynes, writes the following. As the court stressed at the very beginning of this case implicates significant issues. And in resolving those issues, this court's unflagging obligation is to apply the law as written. And when the court does so, it finds that Trump's proclamation complies with the law, and also finds that Trump must provide greater notice, give him 3 weeks. But having done its job, the court now leaves it to the political branches of the government and ultimately to the people who elect those individuals to decide whether those laws and those executing them continue to reflect their will. Great decision from Judge Stephanie Haynes, U.S. District Court judge here, saying, look, man, she might even disagree with this, but they're not actually, a big threat or whatever, but Trump checked the boxes and they don't get to substitute their judgment because they're not accountable to the people. Trump is. His administration is. Rubio is. If the American people are mad about this, they can speak to their representatives and they can impeach all these people and remove them. But they know that the people are happy with this, which is why the hack judges, who are not Stephanie, are doing everything they can to insurrect the operation of the executive branch. But Stephanie Haynes, District Court judge, delivers a nice victory to the president. And now we've got 2 cases now. The other one in Texas is joining this one. We're starting to see victories consolidate. We're going to be here continuing to cover this case and more. Thank you for subscribing and joining as we do.